Hi everyone, thank you for joining us for our critical assignment presentation on Senate Bill 1391, Juvenile Justice, with Aftab Hussain, Amber Bach, and Richard Miller for MPA 570 Public Policy Analysis. Senate Bill 1391 was introduced by Senator Ricardo Lara and Senator Holly Mitchell as part of the Public Safety and Rehabilitation Act of 2016. It amended Proposition 57, Section 707 of the Welfare and Institutions Code relating to juveniles. It repealed the authority of a district attorney to make a motion to transfer a minor from juvenile court to a court of criminal jurisdiction. In a case in which a minor is alleged to have committed a specific serious offense when he or she was 14 or 15 years of age, unless the individual was not apprehended prior to the end of juvenile court jurisdiction. The issue being addressed is the minimum age that the state of California can try a minor. Senate Bill 1391 changes the minimum age from 14 years old to 16 years old. This bill increases the number of minors retained under the jurisdiction of the juvenile court while imposing state-mandated local programs. The issue with the previous law is that too much power was given to the district attorneys over the judges. District attorneys were permitted to make a motion to transfer juveniles at the age of 14 and 15 years of age to a court of criminal jurisdiction without ever having to consult with a judge and perform any sort of fitness hearings. This law emphasized punishment and negativity rather than rehabilitation and positive influence for the minor. In addition, the previous law did not take into account neuroscience or scientific advancements that showed younger brains are different both structurally and functionally from older brains. The brain continues to develop throughout adolescence and into adulthood, specifically the prefrontal cortex located in the frontal lobe. This portion of the brain controls executive functions such as logical decision-making, emotional regulation, problem-solving, and anticipation of consequences. Advocacy groups argued that due to this biological predisposition, it would not be just to try a juvenile as an adult because they do not have the same cognitive capacity as an adult. The previous law strayed far from the original intentions of the juvenile justice system, which was rehabilitation. They were not utilizing social workers in the manner that would best benefit the child. A social worker is trained to deal with issues involving intervention methods such as group work, involuntary clients, and involving family members in the overall process to strengthen systems and sustain change. From a social worker's perspective and an ecological viewpoint, they are able to provide additional reasons as to why the young person is behaving the way that they are. In addition to the biological factors, family life, school life, and community or neighborhood life affect the behavior of a young person. Preventative measures that social workers would be looking for is reforming family life, school life, and community life, because encouraging healthy behavior will then ultimately result in healthy behavior. The greatest problem with the previous law is that it may violate the juvenile's Sixth Amendment right to an impartial jury. Studies have shown that when jurors are informed that a juvenile is being tried as an adult, they are more inclined to reach a guilty verdict because they already form negative convictions of the defendant. The Sixth Amendment right states that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of accusations, to be confronted with witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. According to this study, the group would not be considered impartial because they are already making decisions based upon the juvenile's age rather than the overall case. The issue with juvenile justice began back in 1994 with the passing of the Assembly Bill 560. This was the first time in state history that juveniles aged 14 and 15 could be tried and sentenced as an adult. Prior to the passing of this bill, the minimum age a juvenile could be tried as an adult was 16. This law came into effect during an era of violent crime in the state of California. The late 80s and early 90s saw homicides committed by juveniles quadruple. Lawmakers and law enforcement were under increasing pressure to crack down on this type of behavior. This is where the Tough on Crime and Adult Time for Adult Crime initiatives began. The peak of this crackdown occurred in 2000 with the passing of Proposition 21. Proposition 21 changed the procedures in which juveniles were transferred from a juvenile court to a court of criminal jurisdiction. Juveniles 14 years of age or older charged with committing certain types of murder or serious sex offenses generally would no longer be eligible for juvenile court and would be tried as an adult. This proposition also gave prosecutors the authority to directly file charges against juvenile offenders in adult court under a variety of circumstances without receiving permission from the juvenile court. Prior to the passing of this bill, prosecutors had to hold a fitness hearing with the judge making the decision in order to try a juvenile in an adult court. With the passing of this proposition, that was no longer necessary. 13 years after the harsher dealings with juveniles began, Senate Bill 260 was passed in September of 2013. This was the kickoff or beginning of many juvenile justice reforms. This bill addressed youth offender parole hearings. Under the new law, the Board of Parole Hearings must consider releasing offenders who were convicted under the age of 18 after 15, 20, or at most 25 years behind bars. The passing of Senate Bill 260 led to the overwhelming support and ultimate passing of Proposition 57 in 2016. This bill emphasized the enhancement of public safety with the use of rehabilitation to stop the revolving door of crime. However, this bill still kept power in the hands of the district attorneys. District attorneys still had the authority to make a motion to transfer a minor from a juvenile court to a court of criminal jurisdiction without judges' approval needed first. 3 years after the passing of Proposition 57, Senate Bill 1391 was signed into action by Governor Jerry Brown in September of 2019 after nearly 8 months of deliberation. This undid one of the final remnants of the state of California's tough on crime era. It brought the minimum age of being tried as an adult back to the age of 16. It also shifted the decision-making process back to the judges. This bill intended to reform the criminal and juvenile justice systems by addressing historic inequities and lessening the harm of systems involvement. Senator Lara explained that age-appropriate treatment can be conducive for the adolescent and produce effective rehabilitation to prepare the adolescent for a second chance to be a positive member of society.
AB 1391, there are quite a few of them. First of which is police officers, as police officers are often the first point of contact in the juvenile justice process. And police officers tend to stop teens and young adults approximately 40% of the time. And due to this scientific reason, the children are not capable of rational decision making. Parts of the criminal justice system have changed. Another stakeholder are prisons and prison staff. When it comes to prisons, if we eliminate the ability to try 14, 15-year-olds as adults, you would essentially reduce the potential for more inmates in our already overcrowded jails. And state legislators also consider the fact that given the young age, the ability for rehabilitation is far more achievable than that of an adult. Juvenile court judges, they often influence the way in which others view children before the court, and their decisions set the standards with the community and in the system connected to the court. And judges want to ensure that they are protecting what is right for the juvenile to help them become a productive member of society. Probation officers, they instead of going to juvenile detention centers, children can be placed under probation. Probation should be used to rehabilitate offenders and lessen the chances that a youth reoffends. And also, probation officers work to steer these youth in the right direction, because as stated earlier, children are not able to make those rational determinations on their own. Attorneys are another stakeholder. They're motivated by political gain, and their position will reflect what they think will benefit them the most. And prosecutors are concerned that their ability to uphold the law and charge minors with felony crimes that should be heard in a court of criminal jurisdiction as opposed to a juvenile court. The voters in California, they agreed with the idea that trying a minor age 14 or 15 would be unfair to them, because there could be potential rehabilitating the minor through the juvenile facilities in our state. And voters, when we reference voters, we're talking about any voter, whether it be state, county, or local agencies. Mental health providers may see the bill as taking a step back to the initial focus of the juvenile justice system. The juvenile justice was originally intended to be both rehabilitative and preventative approach to crimes committed by children. And with more than half of all youth offenders suffering from mental health disorder, it would be imperative to incorporate mental health treatment and program options to improve the juvenile justice system. Schools are a stakeholder, but they do not have the necessary resources to address the issues of children that commit crimes. Many of our schools are just overcrowded, and it's hard for schools to focus on these types of issues. And then also by implementing problem-solving strategies into the school curriculums to prevent problem behavior early on, the child may never increase their defiant behavior and therefore reduce the risk of long-term issues. Victims are another stakeholder. Victims or victims' families may question the validity of SB 1391 and why a juvenile gets a lesser sentence in prison because they are a juvenile. People tend to want, if somebody has harmed them or their loved one, they in turn want that person to be harmed or punished in a manner appropriate. And AB 1391 will prevent what these families may view as just punishment for the crime committed. And then the parents of adolescents, parents of the adolescent charged of a crime, would probably be thankful that the child was provided with a second chance. And parents will always have the emotional aspect attached to their wants and desires rather than logic or reason. Last one would be the taxpayers as far as a stakeholder. And taxpayers are a stakeholder because locking up a juvenile costs the state an average of $407 per person per day. So if you are putting more people in jail, it costs more, you have to build more jails, and that in turn affects taxpayers. Decreasing the youth incarcerations may be the best interest of the taxpayers because the money could be used elsewhere. And while the taxpayers did approve this bill, it was done so with the information of what backlash there would be over these reduced sentences. The policy models that were used for AB 1391, first one is institutionalism. The Constitution of the United States establishes the fundamental institutional structure for policymaking, which was what was followed when AB 1391 was adopted. As key components to institutionalism, it allows for the separation of powers and checks and balances among the legislative branches in our state government, in which the same applies to the federal government. As we can see from the adoption of AB 1391, it went through the House, the Senate, went through subcommittees, went back and forth to make sure that all amendments and changes were approved by both houses. Another component of institutionalism is that it incorporates federalism, in which both the federal government and state governments can each pass their own laws. The system of checks and balances and full review by state legislatures allows for any and all issues to be addressed. Then another policy model was incrementalism, which was first introduced by Charles Lindblom during the course of the rational model of decision making. Incrementalism is conservative in that existing programs, policies, and expenditures are considered as a base, and attention is concentrated on new programs and policies and on increases, decreases, or modifications to current programs. And incrementalism is policy expedient, which benefits all parties involved. As we can see from SB 1391, it took roughly 7 months from introduction to adoption for this policy to be approved by the state legislators.
The relationship between juvenile courts, the juvenile justice system, and forensic clinical psychology is very important in order to evaluate psychological and other mental problems by psychologists and mental health professionals since the inception of the idea of juvenile courts and justice system when the first juvenile court came into existence in Illinois in 1899. Other states adopted the idea of juvenile courts and justice system thereafter. Since then, the idea of juvenile courts and justice system has been adopted by almost all developed countries in the world. In the beginning of 20th century, the Industrial Revolution, adoption of child labor laws, and implementation of compulsory education laws contributed to the development of juvenile courts and justice system. Since then, juvenile courts and juvenile justice system had undergone significant changes. Juvenile courts and juvenile justice systems are designed to be more rehabilitative, less punitive than adult courts. Therefore, psychologists, social workers, and mental health professionals play a significant role during the legal proceedings in less formal setting than those of adults. Some consider such proceeding setting counterproductive. Senate Bill 1391 was an effort of criminal justice reform with intentions to have a different outlook on California's tough on crime stance that led to many mistakes in rehabilitation of juvenile offenders. Historically, California's juvenile court had to declare a minor to be unfit for juvenile system before prosecuting the minor in the adult court system. Senate Bill 1391 prevents prosecutors from charging 14 and 15 years old in adult criminal courts. That was passed in both houses of legislature and signed by Governor Jerry Brown on September 30th, 2018. Since the bill passage, many state prosecutors and other groups have challenged the law on the basis of the bill being unconstitutional because it impressively amends two prior ballot initiatives. The proposal of Senate Bill 1391 was to enhance the public safety and reduce crimes by rehabilitating 14 and 15 years old in the juvenile system. It required prosecutors to petition to a judge before charging children as adults. Senate Bill 1391 re-established the adult prosecution provision from age 14 to 16 years old. Senate Bill 1391 is intended to further strengthen the core purpose of Proposition 57, that is to reduce crimes by rehabilitating youth that are accused of crimes through the juvenile system and enhance public safety. Proposition 57 and Senate Bill 1391 are consistent and complement each other to rehabilitate youth that are accused of crimes in the juvenile system. Arguments made by some prosecutors against Senate Bill 1391 have failed to recognize the core purpose of the legislative history and disregard the research-based purpose on which Senate Bill 1391 and Proposition 57 were enacted. Challenging a legislative statute on the basis of its constitutionality comes with a heavy burden. A statute is enacted by a legislator under established principle is considered to be constitutional and must be held unless its unconstitutionality unmistakably appears. Opponents of Senate Bill 1391 have argued that the bill unconstitutionally amends Proposition 57 by mischaracterizing the law to create doubts and develop a controversy by stating that Senate Bill 1391 amends Proposition 57 in a way inconsistent with proposition purpose. The argument for and against in a series of cases in different courts revolve around three key issues of: 1. Does Senate Bill 1391 further the purpose explicitly mentioned in the Proposition 57? 2. Did voters specifically intend in Proposition 57 the transfer of 14 and 15 years old to adult courts, therefore making Senate Bill 1391 inconsistent with Proposition 57? And 3. Whether the intended drafting history of Proposition 57 demonstrates a voter intent that Senate Bill 1391 disregards. Santa Clara County District Attorney petitioned a writ of mandate to the 6th Appellate District Court requiring the Juvenile Court to conduct a hearing on the basis whether a minor defendant should be transferred to criminal court. The Juvenile Court declined to hold a transfer hearing on Senate Bill 1391. The District Attorney challenged the constitutionality of the Senate Bill 1391 on the basis that Proposition 57 was amended unconstitutionally, that abrogated prosecutors' ability to move for transfer of minors who are 14 and 15 years of age to adult criminal court. The court held Senate Bill 1391 as being constitutional because it is consistent with and furthers the intent of Proposition 57, and accordingly the petition was denied. Similarly, the District Attorney at County of Solano filed a petition of writ of mandate asking to strike down Senate Bill 1391 and argue that the new law is unconstitutional because it is inconsistent with and does not further the intent of Proposition 57. After the District Attorney mentioned to transfer a defendant to adult criminal court was denied, the Court of Appeal disagreed and denied mandamus relief. According to California Constitution Article 2, Section 10, subsection C, an initiative statute cannot be amended by a legislator without a vote of the people unless the initiative statute permits amendment or repeal without the elector's approval. Proposition 57 provision allows amendment by a majority vote of the legislator, but only if these amendments will further the intent of the proposition. At minimum, these amendments are consistent with intended purpose of Proposition 57. The main purpose of Proposition 57 as it relates to juvenile justice was to ensure that youths who are accused of crimes get the opportunity for rehabilitation within the juvenile justice system. Studies and evidence overwhelmingly suggest that 14 and 15 years old who are kept in the juvenile systems are less likely to recidivate than of those who are transferred to adult criminal justice system. The intended purpose of Proposition 57 is articulated in court decision where California Court of Appeals decision explained that it was the intent of the electorate in approving Proposition 57 to increase the number of minors who could potentially stay within the juvenile justice system with the sole intent of rehabilitation rather than placing an emphasis on punishment. Similarly, the California Supreme Court has acknowledged that Proposition 57 was intended to improve and implement positive changes to the criminal law with intention to amend or extend as broadly as possible. That included the ameliorate juvenile system and the punishment for mainly juveniles. Courts have made their decision explaining the initiative's purpose drawn from a purpose and intent section of Proposition 57 that states that the proposition was designed to 1. To protect and enhance public safety, 2. Reduce wasteful spending on prisons, 3. Prevent federal courts from indiscriminately releasing prisoners, 4. Decrease crime by increasing emphasis on rehabilitation, especially for juveniles, and 5. Require a judge rather than a prosecutor to decide whether juveniles should remain in juvenile courts or in adult court. Senate Bill 1391 mirrors and extends the policy goals and legislative intent that was stated in Proposition 57. The passing of Senate Bill 1391, the legislative body found the bill consistent with furthering the intent of Proposition 57 that raising the age of adult prosecution furthers its policy goal that will help enhance public safety, reduce recidivism, reduce prison cost, and provide an opportunity to rehabilitate youth in juvenile system. The legislative action relied on decade of research that have shown that prosecuting youth offenders as adults does not result in increased public safety. Documented cognitive research has shown that young people are less culpable and are more susceptible to rehabilitation in juvenile criminal system. The juvenile justice system and legislative history of Senate Bill 1391 recognize that research has shown that young people are not fully developed at age 14. Similarly, science has shown that youth who have committed crime are capable of change with proper rehabilitation. Juvenile justice reform must include the not so easy task of managing delinquent youths. Delinquent youths are not like ordinary youths. They are involved or have committed crimes, in many cases serious to vicious crimes, leaving victims and their families with disrupted lives or worse in some cases. These delinquents come from broken or often from violent homes that lack core family support system that we often take for granted. In many cases, delinquents suffer from mental, physical, or emotional disabilities that can result in erratic behavior during confinements. Juvenile justice reforms effectiveness requires decision makers in all three branches of the state government to make difficult choices necessary to recalibrate the delicate balance between rehabilitation and incarceration. In some cases where it is appropriate, police and prosecutors should be open to non-secure rehabilitative programs for young offenders. The state governor and legislative body must find and advocate for alternative community-based programs, and judges play their integral part by embracing continued efforts at minimizing juvenile delinquency. The reform to the juvenile justice system must diminish the influence of race while charging youth rather than looking at the severity of the charges and prior records. Overrepresentation of racial and ethnic minorities apparent in every level of juvenile justice system. There have been significant increases in issues of disproportionate minority contract in juvenile justice system, resulting in Congress passing the disproportionate minority contract mandate. This provision requires states to reduce the proportion of minorities being confined in public institutions. States are failing to make good faith efforts to help reduce racial disparities in their system and or risking losing their federal funding for justice systems. Juvenile justice system was designed to protect public safety, hold minors offenders accountable, and provide rehabilitative services to them. Unfortunately, when the other social safety nets fail, youths are frequently ending up in juvenile system with mental illnesses. These youths require proper mental evaluation, treatment, and resources necessary to meet their needs. This is a critical time for California to make positive changes in the way and how it delivers mental health services in the juvenile justice system. Evidence-based practices and rehabilitative models should lead the juvenile justice system in California. Thank you. This concludes our presentation.